There's an important Supreme Court case coming up for oral arguments this week that we really need to discuss. This case is building on a previous Supreme Court decision that was unanimous, with all 9 justices agreeing. That earlier ruling had to do with our constitutional rights to keep police from entering our homes without a warrant. But before we get into all of that, I need you to do something really quick. Smash that like button right now if you care about protecting your rights. It only takes a second, and it makes a huge difference in getting this information out to more people who need it. Also, if you're not already subscribed to the channel, hit that subscribe button and turn on the notification bell so you don't miss any future updates on your rights. Trust me, you're going to want to stay informed about this stuff. So let's talk about this new Supreme Court case that just got accepted for review. It deals with the circumstances under which police officers can come into someone's house without getting a warrant first. This case is trying to use a previous decision from the Supreme Court where all 9 justices agreed, and that earlier case involved police taking firearms from a home without a warrant. The new case that's currently waiting to be heard by the Supreme Court is called Case versus Montana. This is a really significant case for people who own guns because it's all about when law enforcement can use certain legal loopholes to not just enter your home without a warrant, but possibly take your firearms as well. The oral arguments for this case are scheduled to take place next week on Wednesday, October 15th. Something else that's really noteworthy about this case is that the Trump administration just got approval to take part in those oral arguments, and they're going to be arguing on the side of the state of Montana and supporting their position. This case is trying to use and build upon a previous ruling where the Supreme Court unanimously decided in favor of the defendant in a case called Janiglia versus Strong. Now, let me explain what actually happened in the case we're discussing today. It involves a man named Trevor Case and his ex-girlfriend. She contacted the police saying that Trevor had called her and she had a bad feeling about some of the things they talked about. When she showed up at his house with police officers, she told them she couldn't remember his exact words, but she had a bad feeling and thought maybe he would get into a shootout with the police. When the 4 police officers got to the house, they looked through the windows into the rooms but didn't see Trevor anywhere. One of the officers noticed there was an empty handgun sitting in a holster along with a notepad. The police officers knocked on the door, shined their flashlights through the windows, and called out for Trevor, but there was no response. After sitting outside the house for about 40 minutes, the police officers made the decision to go inside through the front door, which wasn't locked. Once the 4 police officers got inside the house, 2 of them headed upstairs, and one of those officers went into an upstairs bedroom. When he entered that bedroom, he saw a closet curtain jerk open. According to the official reports, the police officers say they saw the curtain open and they saw Trevor's face along with what the officer thought was a black object. Because of this, the police officer fired his gun at Trevor, who was in the closet. The bullet hit Trevor in the arm and then went through and also hit him in the abdomen. However, Trevor and his family tell a different version of what happened. They say that when the police officer came into the room and saw the closet curtain jerk open, he fired a single shot in just 0.4 of a second. That wouldn't have been enough time to actually see Trevor's face or identify any black object. Instead, they believe it was more likely an accidental discharge or a startled reaction from the officer. Actually, the police officer himself said at the scene that he saw the curtain moving and, in his own words, he just let one fly. Because of everything that happened, Trevor is arguing that the officer entering his home without a warrant violated his 4th Amendment rights, which means the gun and any other evidence they found should be thrown out and not allowed in court. But those arguments didn't work in the lower courts, and they were also rejected by the Montana Supreme Court in a 4-3 split decision. Now this case has made its way up to the United States Supreme Court, which agreed to hear it, and oral arguments are happening next week on Wednesday. The main question the Supreme Court has to decide is whether law enforcement officers can enter a home without a search warrant based on less than probable cause that there's an emergency happening, or whether the emergency aid exception actually requires probable cause. Case is also making the argument that the search wasn't justified under something called the community caretaking doctrine, which the Supreme Court recently struck down in that case I mentioned earlier called Janiglia versus Strong. If you don't know about what happened in the Caniglia case and why it matters so much and why they're trying to expand on that decision, let me fill you in. In that case, there was a husband and wife who got into an argument. During their argument, the husband pulled out a handgun, placed it on the table, and said to his wife, "Why don't you just take it and put me out of my misery?" After that happened, the wife decided to leave the house and spent the night at a hotel. The next morning, she tried calling her husband, but he didn't pick up, so she decided to call the police. She and the police officers went to the home the next morning and found that Mr. Caniglia was on the front porch. Everything seemed fine, but the police officers were still worried about the husband. Because of their concerns, the police officers suggested that he should go to the hospital for a psychiatric evaluation. They took him to the hospital, but before they did, Mr. Caniglia had a conversation with the police officers where he specifically told them that he did not consent to them taking the firearms from his home. He made it clear he didn't want them confiscated, and the police officers agreed that they wouldn't take the guns. But here's what actually ended up happening. After Mr. Caniglia left the home to go to the hospital, the police officers basically lied to the wife. They went to her and claimed that her husband did consent to them taking the guns, even though he had said the opposite. The wife, believing what the police told her, let them into the home, and they took all the firearms. This led to a lawsuit being filed, which eventually went all the way to the Supreme Court. In 2021, when the Supreme Court reviewed the case, they issued a rare unanimous decision with all 9 justices voting in favor of Mr. Caniglia. The Supreme Court struck down the community caretaking rationale that was used to justify entering the home and taking those guns. But now the Supreme Court is going to revisit these issues and hear another case next week. In this current challenge brought by Trevor case, the Trump administration recently filed what's called an amicus brief supporting the state of Montana's position. In that brief, the Trump administration argued that the Fourth Amendment standard in these emergency aid cases should be reasonableness, not probable cause. Their argument is that probable cause only applies to warrants, not to every single type of search or seizure. And since emergency aid entries happen without warrants, the only requirement should be that they're reasonable under the circumstances. So in this case, the Trump DOJ and the Trump administration are pushing for a lower reasonableness standard for these kinds of emergency aid situations rather than something like probable cause. The Supreme Court has also given permission for the Trump administration to participate in the oral arguments on Wednesday. This means the Trump administration will get to argue in support of the state of Montana and the reasonableness test that Montana is trying to use to justify what the officers did. Recently, Trevor Case filed a reply brief, and in it he argues that this court has refused to adopt a third Fourth Amendment threshold between probable cause and reasonable suspicion, and that a vague reasonableness test is an especially poor candidate for that kind of approach. He points out that the officers, firefighters, social workers, and paramedics who have to assess emergencies need the relative simplicity and clarity provided by probable cause, not a rule that confuses even its own proponents. He argues that this court should stick with the textual and traditional standard of probable cause. In the reply brief, the attorneys for Trevor Case also point out that even the Trump administration and the state of Montana don't agree with each other in their briefs about how to apply the reasonableness test. They have different approaches. Based on that, he's arguing that the Supreme Court should reject the whole reasonableness test and instead keep the probable cause and reasonable suspicion tests even in these kinds of emergency situations, especially when you're dealing with someone's home, which should be treated as their castle. This case is important because it affects everyone's protections against these kinds of warrant exceptions. The Supreme Court now has a chance to clarify or expand on that previous unanimous decision from the Caniglia case, which could have direct downstream implications for what protections we all have from police officers and the federal government and other officials entering our homes under these warrantless search and seizure exceptions in emergency situations. Like I said, oral arguments are happening this coming Wednesday on October 15th. But it's also really interesting that the Trump DOJ is now going to be able to participate in those arguments and argue on behalf of the state of Montana. This week, we're going to get a lot of valuable information from the Supreme Court based on the hypothetical scenarios and the questions that they ask during oral arguments. We should be able to get a pretty good sense of how the Supreme Court is planning to approach this case. So we're going to be paying close attention and listening carefully to figure out how they're going to handle this situation. As more information becomes available and as things develop further, I'll make sure to keep you guys updated. If you found this information valuable, do me a favor and hit that like button right now. It helps get this critical information in front of more gun owners who need to know about these changes. And if you haven't subscribed yet, make sure you subscribe to the channel and turn on notifications so you never miss an update on your rights. Share this video with every gun owner you know because this information is too important to keep to yourself. Thanks for watching, and I'll see you in the next one.